Good afternoon and welcome. My name is Jimmy Sangenberger. I'm President and CEO of the Liberty Day Institute. We're going to wait for this special edition program.
Thank you. When I said when I came in and exactly. Right. I think you'd be fully exhausted, but I did not say So we've already started, but we told them that we're just holding for a moment, so we can go ahead and get in place over here. All right, Karl, you can get in the middle.
How's it going? What's your name? Derek. Ron. Karl. What's your name?
Good morning.
How are you? I'm nice to meet you, honey. Karl. Dan, good to see you. What's your name, brother? See you. How you doing? Okay, guys. Nice to see you.
I brought my constitution.
So Andy, let me give them a quick rundown and then I'll let you start.
Right.
So we have an online audience, so remember to speak a lot to the camera as well, but also speak to our audience too. Jimmy's gonna kick it off, then he'll send it over to you. You'll introduce yourself. We'll pan around to the kids, let them say hi when you're talking about Roosevelt. We're going to introduce both of our panelists, and then Jimmy will start with the Q&A.
Okay.
Great. So Jimmy, are you ready?
Yeah, if we could just have everybody for just a moment, and for those of you just joining us, my name is Jimmy Sangenberger. I'm President and CEO of the Liberty Day Institute. So that I know who is who, if you could each please introduce yourselves, I would appreciate it. And let's start with the Attorney General.
Sure. My name is Karl Racine. I have the privilege of serving as the district's Attorney General, first elected Attorney General here in the District of Columbia. Peter, do you want to introduce yourself?
I'm Peter Edelman. I'm a law professor at Georgetown Law Center here, of course, in our city, and I do teach constitutional law.
Excellent.
That doesn't. That's the end of the statement of expertise.
Hi, I'm Jeffrey Robinson. I'm a lawyer in private practice in Washington, D.C., formerly at the D.C. Attorney General's office and various other government places.
Wonderful. Well, we appreciate you joining us this afternoon on what we call our Visiting Scholars Program, and it's an opportunity for you to learn from those who are involved in the Constitution on a regular basis. Once again, for those of you just joining us, my name is Jimmy Sangenberger. I'm President of the Liberty Day Institute. In the middle, we have the Attorney General of the District of Columbia, Karl Racine. We also have Peter Edelman, and Professor Peter Edelman, and Jeffrey Robinson, and those gentlemen are with us, and we're very excited to have you here and to be at Theodore Roosevelt High School. It really is just a true pleasure to be with you and to have this opportunity to answer questions from students on the Constitution, which is such an important document. And I want to get started due to time with our questions and jump right in. And start with the Attorney General. So first, if you would like to say a few words, Mr. Attorney General, to welcome the students that are watching both in the audience and also those that are visually watching on the computer.
Sure. First of all, let me talk to the human beings in front of us. And these are fantastic students from one of DC's best high schools, a high school that has been completely and totally physically renovated. We have, my goodness, probably about 15 students in the room. and they're eager to talk about the Constitution. I want to say hello also to the online community, and thank you to my colleagues and friends. To my right, Peter Edelman, and to my left, Jeffrey Robinson. Let me talk just a little bit about today's Google Hangout. It's a moderated discussion about the Constitution of the United States, which is, really the most important document and the cornerstone of the democracy that we have here in the United States. Peter Edelman is a professor at Georgetown University. Mr. Edelman teaches con law and poverty law. Mr. Edelman is also the faculty director of the Georgetown Center on Poverty and Inequality. Through Mr. Edelman's work over some decades, using the law as a tool to help poor people have a better shot in America, Mr. Edelman has done incredible work. Peter served for former President Kennedy, if I'm not mistaken, and has been an advisor to many presidents and other stakeholders who care about the rights of all Americans. Also joining me is Mr. Robinson, Jeff Robinson, a longtime friend. Jeff is a well-known and highly regarded civil rights lawyer in the District of Columbia. Jeff has done many things in his incredibly interesting career in the law, including having served as the Associate Director and Counsel for the NAACP Legal Defense and Education Fund. Not so long ago, Jeff played an important role in the constitutional battle that concerned a presidential election way back in 2000. That was Vice President Gore running for president against George W. Bush. Incredibly close call that eventually went up to the Supreme Court, and the Supreme Court determined that George W. Bush had the votes to go forward with his presidency. You fought hard on that case, and we appreciate that.
You were right, too.
And you were right also. Sometimes the court gets decisions wrong, we say, but under our system of the rule of law, when the Supreme Court makes its decision, they have the final word, and we have to respect it for that time period until we get another shot to make sure they get it more right according to our values the next time. That's my introduction. I'm sorry for babbling so much.
Not a problem.
I should tell the students here that I know that I love you much because I'm a DC person. I went to Murch Elementary, Dale Junior High, Wilson Tigers. Used to always beat up on the Rough Riders of Roosevelt, but that's okay. It's good to be here in Rough Rider territory.
Wonderful. Well, we are so thrilled to have you participating in this and taking the lead. So thank you very much, Mr. Attorney General, for joining us this afternoon for what I think is going to be just a very fascinating discussion on the Constitution. And the basic question that I want to start with here is for you, Mr. Attorney General, and that is, what is the U.S. Constitution, and why should the average person care about it?
Well, thank you for the question. The U.S. Constitution is, as I indicated, the most important document that really establishes the baseline constitutional rights that all of us living in America have. Important rights like the right to speak our mind, the First Amendment, right? How many of you out there in the audience at Roosevelt appreciate the First Amendment right to free speech? Can I get a shout out just in case they can't hear you? Yeah. That's what I'm talking about. That's what I'm talking about. There's of course, a Second Amendment right that relates to the right to bear arms. That's a controversial right that is now being tested in the courts. We also have important rights that protect us as folks living in the states from unlawful seizure and arrest, and from not having to testify against ourselves. These are core protections in the criminal justice system. So our founding fathers tried to get everything right. They were not perfect, but they went about defining a constitution that would enshrine very important basic rights. The other thing I'd say is that because our founding fathers didn't get everything right, the Constitution had huge gaps. For example, when the Constitution was established, there was still slavery. And so the Constitution did not correct the clear wrong of slavery, but thankfully through an amendment process, right? Anybody know which amendment eradicated slavery? Pretty good there, 13th Amendment. We'll get to you on the 27th. I know you're thinking hard there, but 13th Amendment eradicated slavery. So what's important is that the Constitution, in my view, is a living document that still allows us to make changes to it to really match our values of what's important.
All right. Well, if you gentlemen, Peter Edelman or Jeffrey Robinson, have any interest in chiming in on some of these questions, please feel free to join in. I do want to go to the second question, though, which is very much a part of life and curiosity in the District of Columbia. There is a renewed push in D.C. for statehood, and officials are drafting a constitution. How is the drafting of this constitution similar to the drafting of the U.S. Constitution?
Boy, that's a hard question. Before I answer that, maybe I'll kick that over to Peter and to Jeff. Let me give you a few facts about D.C. that if you don't know, as high school students in the District of Columbia, I urge you to really put your heart around this and get passionate about it. So in the District of Columbia, do you know when it was the first time that citizens in the District of Columbia could vote for the President of the United States? Do you think that happened in 1776? How about 1850? 1960, right? Not so long ago. So the District of Columbia is not a state. And even though it is the nation's capital, it basically is governed and controlled by Congress. Congress gave the District of Columbia what we now have, which is limited statehood, where we have a mayor who we elect, a city council who we elect, and now even an attorney general who we elect. But in a real way, the District of Columbia does not have the same voting rights, same democracy as exist in other states. Why is that? We have a congresswoman. Anybody ever heard of Congresswoman Eleanor Holmes Norton? Yes, very smart. One of Professor Edelman's former colleagues at Georgetown Law. Unfortunately, because Congress has not done the right thing, Congresswoman Eleanor Holmes Norton doesn't have a vote in Congress. That makes the District of Columbia the only national capital in the world where its residents, you and me, everybody here, don't have a vote in Congress. It's outrageous and it needs to end. And that's why DC is focusing on statehood. Can I put?
I mean, I think it's what you said at the beginning. The founding fathers wrote a constitution which sort of defines how things operate, but they didn't get everything right. And the District of Columbia was left out of important protections. I think you'll hear later about other people who were left out of important protections. And the district writing a constitution for a new state is a sort of an attempt to assert its own rights in the same way that the founding fathers asserted their rights. They were faced with an injustice, and they used the sort of larger notions of what government and freedom should look like in order to make their argument, make their case for why they were entitled to it. That worked in 1776, 1787, the Constitution was formed, and hopefully through the work of Attorney General Racine and others who have been pushing on it, that's a success that the district can have, and that its constitution can sort of help shape and define how it exercises those rights.
Very well said. Professor Edelman, would you like to give an example or two of where not being a state, still having Congress as in the background, able to veto things that we do, hurts the District of Columbia?
Well, General, of course, we're the last colony. And so the last time we had new states was Alaska and Hawaii in the late 1950s. And it should be done for us. And what happens when we pass a law through our city council, every law has to go up to the Congress and essentially either wait there for a period of time and then it gets to go into law, or it can actually pass its own law that stops the law in the District of Columbia. So this means, unlike any other part of the United States, our laws are not laws at the point of time, as though the state of Minnesota's law or New Mexico or any other place. That's the big thing. Our budget has to be, again, approved by Congress. And when they feel like it, they can pass a law on their own that tells us what we can and can't do. They add things that are called riders, or one way or another. They tell us what we cannot do or what we must do. And again, we're the only part of the United States. We're a colony, in real terms. And that's what I've said to you is the way it works.
All right. Well, thank you very much. It's very vibrant and interesting debate, especially I'm here in Colorado at our headquarters for the Liberty Day Institute. And so it is fascinating to me to really hear those perspectives that you're presenting. So thank you very much for sharing it here on the Liberty Day Institute's Visiting Scholars Program. Next question that we have provided is, I think it really strikes core to one of the controversial issues of our time, which is the Second Amendment. The District of Columbia is currently in litigation defending its law regarding permits for carrying concealed guns. Does the Second Amendment leave room for any gun control laws, in your opinion, Mr. Attorney General Racine?
The answer is yes, absolutely. So let me make sure that our students, both online and in the Great Roosevelt High School, understand what we're talking about when we're focused on the Second Amendment. The Second Amendment states in principle that there is a right to bear arms. Then the text of the Second Amendment talks about a militia. Recently, about 6-7 years ago, the Supreme Court of the United States, in a case called Heller, determined that the Second Amendment right to bear arms applies to individuals in their homes. So individuals have the right to bear arms, according to the Supreme Court, for purposes of self-defense in their homes. That's what the Heller decision found. That was the first time that the United States Supreme Court made clear that the Second Amendment applied and gave rights to bear arms to individuals. The question now is, what can states and jurisdictions like the District of Columbia do to exercise reasonable and common sense restrictions on the right to bear arms? The District of Columbia has determined that in order for an individual to be able to carry a concealed weapon outside of the home, that person must demonstrate that he or she has a good reason to fear for his or her safety. That's called the good reason requirement. I'd be very interested in getting the feedback from the audience there. How many of you believe that the District of Columbia is right when it says to its citizens, look, in order for you to have a gun and carry it around in DC, we want you to demonstrate that you have a good reason? Yay or nay?
Nay.
Yay? Can I get the yay? Okay, so it's a close call, and that's okay. In our Constitution and our democracy, we like it when people have debates, and I'm happy that we're having that now. Under the law, though, even in recognizing that there is a right to have a gun in your home, the Supreme Court recognized that the right to have a gun is much more cherished in the home. You're protecting your home, and it can be reasonably restricted outside the home. Why is that? Because when you're carrying a concealed weapon or not concealed, unconcealed weapon outside, you're arguably infringing on the rights of other people, and you're creating a situation where perhaps more danger can occur. And that's the perspective of the District of Columbia. We think that we're right on the law. We had a case this week in DC Circuit Court, which is a court right below the Supreme Court, and we think that we'll win the case. I should tell you that 3 other circuit courts in America, federal circuit courts, have agreed with the District of Columbia's perspective, and so we feel fairly confident in the rule.
Can I add something?
Please.
Just a little background that maybe is helpful. We have this, the Constitution, what those guys did back before the beginning even of the 19th century. Really hard to be sure that everything in here, well, first of all, that everything, that you know what everything means when you read it, because it's got a lot of general language. So we have the Supreme Court. The Supreme Court has 9 members. That means that 5 of them can tell us what the Constitution means. Depending on who those people are, what president put them on, they interpret. And some of the rest of us, quite often, as we said earlier, we don't agree with what was said. There was no right to have a gun under the Second Amendment until about 10 years ago. Never. We went through more than 200 years understanding that the Second Amendment did not mean that there was a person had a right to have a gun. So this isn't something that was clearly a right in 1789. This is something that was frankly made up in 2000 and something. That's part of our system. And so we have to understand how that happens. And I think some of you were thinking in response to the Attorney General's question about maybe you thought, what's this thing about a right to a gun at all? Anyway, that's what we have now. And it's the other thing I want to say to you is that just common sense says you can't say that anybody can have a gun anywhere, anytime. There's no right like that, no blanket right like that. You have to read into it, and the Supreme Court did say, and it's what the Attorney General was talking about, that the states and District of Columbia can regulate reasonably, because people who have mental health problems, people who are criminals, a bunch of people should not ever have guns, and we can have laws to do that. So that's a little bit of context that might help the conversation.
Very good. Very good.
And the debate will continue on this issue as well, especially as we look at what the courts decide in regards to the litigation over the D.C. law. Once again, we are on the Liberty Day Institute's Visiting Scholars Program, and I want to go next to Peter Edelman, because there's some interesting questions here, and I only want to ask a couple more from this list and then get to student questions in the audience due to time factors. But one question that I think is always asked by many students, and I think this is a great question, and that is, why is it so hard to amend or change the Constitution or to add on to the Constitution? Do you think that there will be another amendment that will make its way to being a part of the U.S. Constitution? Professor Edelman.
Well, that goes with what I was just talking about. in this case, we're talking about what the framers, the people who wrote this, did quite intentionally. You have to have, in order to amend this, you have to have a 2/3 vote in each House of Congress, the House of Representatives, the Senate. And it has to be approved by 3/4 of the states around the country. It's very difficult to do that. They did that very intentionally, that it would make it difficult to do that. Also, there can be a convention, a constitutional convention called by 3/4 of the states. And so that's also hard to do. Why? Because they wanted a document, understanding that it has things about it that aren't clear and we have to have interpretations. They wanted to have a law for our country that was above the regular laws of our country, that would guarantee our free speech and all the other things the Attorney General talked about. So that's the answer. That's what we have. Other countries do it in a different way. We pay a certain price in terms of some of the interpretations of the Supreme Court. But I think what the framers did back there, that they were right. And it's hard. I don't know. We may have another Constitution amendment, 27th Amendment you talked about, the last one. But I don't know when.
I mean, in part, they were thinking they didn't want just whatever happened today, whatever we were all upset about today, whatever was on Twitter, whatever we were all upset, say, now we're going to easily just change the country and do it completely different. We want a little bit of something that's solid and real and that you can change it. And if it's important enough to change it and we can go through all the process and do it, we can. And we have. You say there are 27 amendments. So it's not something that happened. The last one was in, what, 1991 or so, added an amendment. And so it happens, but they wanted a document, sort of an instruction manual for how you run the country that is above just however we feel today. And so they made it hard for us. And there's a lot of wisdom to it, although, as you say, sometimes you wish you could change something, something that a lot of people would like to see done differently, and we can't change because of the existence of the Constitution.
Sticking with the subject of constitutional amendments, I do want to ask this question for Jeffrey Robinson, who was just speaking a moment ago. When the Constitution was first written, women and African Americans were not included in its protections. When and how did that change?
I mean, I think there is an example of an amendment. The African Americans were included in the protection in the 14th Amendment in 1868. We had a civil war in order to have that happen. And while the words, Equal Protection Clause and Citizenship Clause, which made African Americans full citizens, happened in 1868, we're still fighting to make that a reality. That the words changed, but then it was interpreted in ways, in a case called Plessy v. Ferguson, that sort of deprived African Americans of power with respect to that. And it wasn't until the 1950s when Brown v. Board of Education and other cases after that started to actually give real meaning to those words. And so I think that's one of the things about constitutions. The words are important, the words are critical, but how they get interpreted and what we do as a country about them is also important. Similarly for women, there wasn't anything that actually said women weren't protected. And arguably, when the 14th Amendment was passed and said everyone should have equal protection, that included women too. But that wasn't the reality. And it wasn't until 1920s, the 19th Amendment, that the Constitution actually said that women had the right to vote. But even then, even once women were granted the right to vote, women still were discriminated against. Yeah, obviously women are still discriminated against in some places, but over time, the court took the Equal Protection Clause, which was designed originally to protect the freed slaves and African Americans, and applied some of its protections to help protect and empower women. But it's a long process and one that continues to this day.
You talk about the 14th Amendment to the Constitution, and another component that is discussed in the Constitution and in some of the amendments is, well, it reads that nor shall any person be deprived of life, liberty, or property without due process of law. Jeffrey Robinson, and then also Professor Edelman, if you want to get in on this question as well, would you please describe in detail what specifically is meant by due process of law?
I think the in detail part would be Professor Edelman's full semester long course at the Georgetown Law School.
Yeah,
but
I think we're going to lose the crowd.
Right. But here's the basic. The first concept and the most important, well, the first concept in due process is fairness. Can't take your life, can't take your liberty, can't take your property without something that's fair. And we think of fairness, mostly we think of court proceedings in which each side gets a chance to be heard, there are rules, there's a fair shot. You know, that's a core meaning of due process, and it's sort of everyday. That's gotten bigger over time because we've realized that just doing something fairly isn't enough, that there are some things that I shouldn't be able to do, even if the process looks like it's fair. And due process has engaged what they call a substantive part of the due process clause, which seeks to protect certain fundamental rights, even if that you can't infringe upon freely. The best example, and we talked about how the District of Columbia is different, there's the Equal Protection Clause in the 14th Amendment. Well, technically, because the District of Columbia is under the federal government, that doesn't apply. The Equal Protection Clause of the 14th Amendment doesn't apply in the District of Columbia. But what the courts have said is that the Due Process Clause, which is in the 5th Amendment, brings all of those protections, equality and fairness, from the 14th Amendment and makes them applicable to us in the District of Columbia, because it would be fundamentally unfair to treat people unequally here, even if without the 14th Amendment.
I would just add a theme that we've said before. Listen to those words: equal protection, due process. What do those words mean? I mean, we could have each of us around the tables here say what we think, and we'd have 10 or 15 different definitions. Those words, as far as equal protection is concerned, were inserted into the Constitution in 1868. It says all persons, and yet there was the discrimination against women that Jeffrey mentioned. So the understanding didn't even, in the simplest way, it wasn't consistent with what the word said in the Constitution. And then on the question of race, again, equal protection to us in some ways seems obvious, and yet we didn't have a requirement that there not be segregation of schools until 1954. If I had to name the most important equal protection case in our country, in the history of our country, and there's certainly many, many to talk about, it would be Brown versus Board of Education. And that, if you think of that in relation to the term equal protection, that's a tremendous example of assuring the equal protection of the law.
All right. Well, I appreciate that, because it really is one of those issues that gets into a whole bunch of case law and so many different things that are elaborate that come underneath the realm of both equal protection and due process of law. So thank you for those cogent explanations, gentlemen. I do want to take this moment to bring up now Attorney General Racine once again to moderate, if you would, a conversation and some questions and answers from the students that are in the audience there at the Roosevelt High School.
Okay. Excellent. We have a volunteer already. Here's the name of the game, though. If you raise your hand, I want you to tell everybody what your name is and what grade you're in, then ask the question.
If you could come up here so that the speakers could hear you.
Perfect.
Yeah.
My name is Randy. I go to Roosevelt, obviously, and I'm in the 11th grade. And I was writing my question when you speak. It's to address something that you said. You said equal protection, but what exactly is equal protection? There is equal protection right now in the streets being served, but what we really need is to learn what equality is, what it means to be equal. We need equity, not equality.
Very interesting. Let me tell you something, Randy. Thank you so much for raising your hand and asking that incredibly interesting and deep question. And I think you posed it to Professor Edelman, the man who's been thinking about these kinds of issues literally his whole life. Peter.
Well, that is a great question. And just the fact that you make the, right,
Yeah.
you make the distinction between equality and equity. Because besides having to define what it is we mean by equal, and that's an ongoing process in the Supreme Court, we have issues about fairness of all kinds of things, particularly about poverty, about what I would say equity with regard to having so many people in our country who have a very low income and a very tough time. And so that raises the question for me of what's the role of the Supreme Court? How much of the work that we want to do to make this a better country can we do by having lawsuits and going to the Supreme Court? And how much really has to operate through a political process where we elect the people, we elect the Attorney General, the Mayor, and our national officials. And if we don't participate in the political process to elect people from the president on down who can make this a better country for everybody, and that's what in a simple way, that's how I define equity, then we're going to lose out. So the lawyers can't do the whole thing, the courts can't do the whole thing. We need the work of our Congress, of our city council, to make the laws that really make this a better place.
Let me just add a couple things there. And as Professor Edelman said, the political process is quite important to getting to a place of perhaps greater equity. President Obama, for example, is going to go down in history as having passed Obamacare, health care for all Americans. And some would say what President Obama believed, and many people believed for decades, is that the right to health care is a fundamental right that all of us should have. That would be an example of equity. Another example, some would argue, is that the right to have shelter, or at least some place to live. No one has yet declared that right, but maybe through the political process, depending on who you're voting for, and it's so important for everybody to play a role in elections. Even if you can't vote, you're not 18, you can still persuade people who can vote to vote the right way. You can still volunteer for campaigns. But it's through that process and the law that some of the equity can be established. You got to come up if you got a question. Come on.
That was
Come on up. That's a great question, though.
So my name is Tanya. I'm in 11th grade, and I had a few questions, but everyone pretty much answered them already. But one of my other questions was, can you basically describe eminent domain?
Wow.
And explain how it relates to DC, and also the problem, well, the issue going on with Native Americans in the pipeline.
Very interesting. I'll take eminent domain. I'll go to Native Americans with you. Okay, very briefly, we talked about equal protection under the law and due process. What eminent domain means is that a government here in DC, since you wanted to know about DC, has the inherent authority to take another's property so long as the use of that property will be for the public good. Okay? So what does that mean? If I'm going to take Peter Edelman's house because it sits on a nice field where I want to have National Stadium where the baseball team plays, that was a real case. It wasn't Peter's house, but the city took the property in order to create National Stadium. The law allows the city to do that, but the Constitution, the rules of the game, fairness, due process, requires the government to pay fair value for the use of that property. Okay? So the best example National Stadium where the Nats play, eminent domain. And the property owners on which that stadium sits were in fact compensated money for the value of the property.
Well, so, and it relates. The question, National Stadium is a great example because the real question is it for a government purpose? So we would all agree that even if I'm willing to pay you for it, the government shouldn't be able to take your house to give it to her, right? That doesn't work, and eminent domain doesn't let you do that. And we might all agree that the government, that you could take your house because I need to build a dam there to keep it from flooding out the whole city. Classic eminent domain. It's for a government purpose. Things like stadiums and other things, the pipeline and other things, raise this question about whether the government's using its power to help somebody else or some other small group of people, or whether it's for a real government purpose. Now, I don't know the details on the Native American. I read it in the news in the way that you have, but I think that's some of the structure, in addition to, sort of people who have been historically oppressed and dispossessed, pushing back against the government using its authority in a way that's going to go to land that is really sacred and holy to them. But there's that. Is this for a real government purpose? In which case you still have to pay the people what's fair, and we always end up fighting about what's fair, or is it really just to help some other private people, which the government's not allowed to do? And the one piece on it, you always hear a lot about conservatives and liberals and different things. This is an area where it almost comes back around. Both very liberal people and very conservative people have real questions about the exercise of eminent domain for private purposes.
Thank you very much.
We have time for one more question, I think.
Oh,
She's got a second question.
anybody else got questions?
Anybody else have a question, or should we go to the law professor, Randy?
Oh, yeah.
That's great.
All right. Again, my name is Randy, 11th grade. I said, I'm not trying to pick on you, but you said, you said that those that was mentally disabled, like unstable, and other people that are incapable shouldn't be able to bear arms. But does that mean they also don't have the rights to protect themselves in their own home, regardless of what they were born with?
The first thing is did not use really a careful enough terminology. I mean, a person who has mental issues that relate to possible violence. So I didn't mean everybody who has some kind of a problem of mental health.
But even those deserve to protect
Well, I think if you're talking about somebody where there is evidence that they could be dangerous to someone else or even to themselves, it doesn't matter whether it's in their house or anyplace else. So with a proper definition, which you're absolutely right, you got me. A careful definition would say that when you have somebody who really is a danger to the community or to themselves, they shouldn't have firearms.
But taking it structurally, taking it in under the rules, that's exactly the kind of issues that constitutions set up but don't answer. How do you balance the different things? Whether in the guns, there's some people, even if there is a personal right to have guns, there's some people who we might all say they shouldn't have a gun. They've used it multiple times in robberies before. There's something, and so drawing those lines and figuring out how the rights apply is what a constitution can set up, but it doesn't answer. We do it in the First Amendment. You hear the famous cases where we all have a right to speak, but somebody can't come in here today and say, there's a fire, and everybody runs out and people get hurt. Not allowed to do that, even though you have a right to speech. You have to balance the things. And I mean, you think you're right to point out where you draw those lines with respect to issues like the Second Amendment and gun control can be difficult, but the constitutional issue, and I think the issue that the district is struggling with in that case is somebody has to draw the line. And does the district or other states under the rules be the entities that's allowed to draw the line?
Thank you so much.
Well,
back to our great moderator.
I appreciate it. Gentlemen, thank you so much for just a fascinating discussion. Attorney General Karl Racine, Professor Peter Edelman, and Jeffrey Robinson. Really appreciate you taking the time. Let's do this again sometime. This was a lot of fun, and I think also that we had some very interesting and engaging questions from the students in the audience, so I want to thank you as well for your participation, for sharing your thoughts and questions. And if you have any final words for us, Attorney General Racine, as we finish up Constitution Week, because tomorrow is the end of Constitution Week. It's September 17th through the 23rd. Any final words of wisdom on the Constitution for our audience today?
Sure. I think, as both Peter Edelman and Jeff Robinson made clear, the Constitution is our Constitution. We have the ability and indeed the right, I would say responsibility, to engage around the Constitution, to get involved in the political process, to make sure that the Constitution is interpreted and helping the people who need it the most. I urge those of you who are interested in going to law school to go to law school. We need more excellent people in the law, and one way to get experience is to volunteer for jobs at offices like the Office of Attorney General. And I look forward to talking to the students here about those kinds of opportunities.
Gentlemen, thank you so much for this opportunity. Yes, let's give a round of applause if we can from those in the audience for our panelists. Thank you so much for doing this afternoon. Really appreciate it, and I wish you the best.
Thank you very much, Mr. Sengenberger. We really appreciate your courtesy. Go.
All right. Go forth and prosper. Thank you so much. I'm Jimmy Sengenberger, President and CEO of the Liberty Day Institute. For Attorney General Karl Racine, Professor Peter Edelman, and Jeffrey Robinson, and the folks at Theodore Roosevelt High School, we thank you very much for taking the time to watch this program, and hope you'll see it live if you've missed it at Liberty Day USA, youtube.com/Liberty Day USA. Thank you very much. Have a great day and a happy Constitution Week.
Excellent. Roosevelt High, live. Look at that.